Well, good morning, everyone. Did you have a good time last night? Okay, I heard you murdered a couple of people and things like that. That's always a good way to end the evening, so. But it did sound like it was a lot of fun and everything, so I'm glad you got to have that opportunity to socialize and enjoy yourselves. But I realize too that all good things must come to an end, so I appreciate the time and the effort, because it is time and effort to sit and to learn. And a lot of times people say, oh, you're going to a conference, and so, woo, you get out of the office. And you do, and it's fun, but it does take concentration. It is tiring to sit and to listen and to learn. So we really appreciate you taking that time and the effort to do that. We recognize that it is time away from your office, and so we always want to make these events valuable for you. And we always have an open door policy that if you've got any topics that you would like to be considered, please send either Lori or myself that information, and we will definitely put that as a considered topic. So please do that. And then if you have any other issues, hints, whatever, you know, we can take it. We want to provide you the best that we can from a training standpoint. So just let us know, and we will always take it into consideration. I don't know that we can always change everything. We realize that there's some things that can always be done better, and we would like to have that information from you. This morning we will be taking off right after our session and before your business meeting. So please fill out your registration forms, and we'll kind of have like a 5-minute or so transition period between us and your meeting. So please get those forms up to us so that you can get that credit so that you can get reimbursed. I would also like to thank your officers again. I knew going in what effort that it took. They've done an amazing job, a wonderful venue. And Lori and I so appreciate it, because it just could not be done without them. So we really do appreciate, and thank you so much for that. And also, I would like to thank Lori and Fred. Both of them are newer to this situation, but have they not just really come through? It's not easy taking on the roles that both of them have done, and I have watched them in the past few months. Lori is more than a right hand. She's a leader. She is just, I can't even put into words how much that she's meant to me the past few months. And Fred, I've just seen him develop and grow on things, his ideas, his passion and everything. And I just know that for the years to come, that they are really, really going to be great resources for you. So I look forward to working with them, and I know that you do too. So thank you very much, guys. I've got some. You guys were very, very good about putting those Q&As in the box, and we really like that, because some of this, in some ways, I think that this is one of the better parts of the meeting, because it really gets into those questions that I know you have and that a lot of other people have too. So I've got some, and then Lori will be wrapping it up for you. So let's go ahead and start. How do you have an exit conference with officials, the commissioners and council, without violating the open door policy, public access? Well, that was a problem. And then the new legislation has taken care of that issue. They have added IC 5-11-5-1, subsection B3, and it now says if a majority of governing body, which would be the county council or the commissioners, is present during an exit, and an executive session is considered in place, but you don't have to give notice about that. So there's none of those rules involved as far as that is concerned. And that was an issue because what would happen is we'd have our exit conference. Usually the presidents of both were involved. And then we'd have to talk with each of the other members either individually or they'd hear rumors of what happened. And that's just not a good way to get that information to them. So that's one thing that was changed by law, and I'm very, very grateful to hear that. Is there a question?
Thank you. I just wanted to add to that because I had that situation come up on May 12th. I wanted an executive session for our council to have a budget training workshop just so that they could learn better how to do the budget. But there's no executive session code to cover that kind of situation. So our newspaper kind of called me out and said, well, you can't do that. And because I kind of made one up, I figured, well, what's the difference between school board learning and the council? They all got to learn as public officials. Dale Brewer from the Public Access Council, the PAC, she said to get around that circumstance, what you do is in the public meeting, you announce, in advance, it's going to be an administrative session, and then you don't have to advertise it. If the public comes, you have to let them in. But there's no advertising necessary, and you can have your full quorum of council.
Okay. Thank you. Tax sale surplus. After 3 years goes to county general. The new ledge says if redemption period has been extended under federal bankruptcy law, we have to wait for the period to end. How are we supposed to know if there's an extension for redemption? And that is a little bit of an issue. You're supposed to be notified about this. I know also that the treasurers in their training on bankruptcy, they have been given websites that they can visit to determine if there's any properties that are under bankruptcy. And I know that a lot of times people are very, because they will come and they'll say, well, you need to wipe off certain penalties and things like that because it is within the bankruptcy time period. So that information most of the time will trickle to you some way. I might even talk with the treasurer to find out what they learned in their bankruptcy training, or we could possibly have training on bankruptcy just so to familiarize you with that. The other thing is, if all else fails, this money is going to the general fund, and so if it comes to your attention that there was an extension, it can get put back. You can correct that error. So I know that was a little bit difficult. Why are the sheriff's commissary funds not required to follow accountability of their funds and expenses? Yes, they have to follow accountability. I've had many findings over the years when that has not been done, and they are subject to all the same rules. They have to maintain ledgers. It's actually right in the statute that they have to have a receipt and disbursement ledger, and twice a year they have to provide that information over to the county council. If there's any question about their accountability, you find that information under IC 36-8-10-21. They have to reconcile to the bank, the whole thing. Sure. IC 36-8-10-21. And it's the very last subsection that talks about the receipt disbursement ledger and that they have to provide that information to the county council. This was a really good question. They're all good questions, but had to think for a second about it. On the large property tax refunds, new law, how does that work with interest? Is interest computed and applied all the first year and they get a 1099 that year, or does it get divided by 5? Or do they get to continue to get interest over the 5-year period? If the last one is the case, how do we report this on the 17TC filed with Auditor State and DLGF? Well, once it's determined that they're owed a refund, IC 6-1.1-37-14, which is the new section, states that all other provisions of IC 6-1.1 apply. So you can elect to apply credits in equal installments, this is under the new statute, to future property tax installments over a period of not more than 5 years following the date of the conclusion of the assessment appeal. Then IC 6-1.1-511 is allowing for that credit. And then, you've got to love statutes. And then under IC 6-1.1-37-11B, this is where it states about the interest and that this is applicable to IC 6-1.1-15. Okay? So there it states that the interest shall be computed from the date on the which taxes were paid or due, whichever is later, to the date of the credit or refund, using the rate in effect from Department of Revenue for each particular year covered by that refund or credit. So, at that time that you determine that there's a refund, and that's why a lot of times even though under IC 6-1.1-15 there's no claim that's required to give the money back or anything, you'll initiate it right away so that you can stop that clock from ticking anymore on the interest. And then you are going to come up with your total amount. You're going to divide it by however many installment that you are going to do, because the 5 is the maximum. It could be less than the 5. And then you apply it. So it's not that there's a continuous change of the interest over this period of time. You are, in effect, giving that person credit right at that time for the time period that the appeal was in place, and then you are applying it over the next however many installments that you're giving them, okay? Now, as far as the 1099 is concerned, I would suggest strongly that you contact the IRS to determine if they consider the benefit to be at the time of application or if it's at the time of calculation. So only they can answer that. I don't know if anybody's had any experience with that. Has there been anybody on different application times? Okay, well, the IRS is the one that you'll need to contact about that. And I will say, we have tried to get the IRS to come. I realize they haven't been at a meeting since 2012, and we dearly would love to have them. I talked to Raylene just about a month and a half ago, and they still have her working on special projects, and they just are saying right now that that is not available use of their resources. So, but we'll keep trying. Gap reporting must be implemented by 2000 for population of 100,000 or more. What if the population is less than 100,000? Well, like we were saying, the legislators, I think, were just trying to get this kicked off and trying to figure out at least a schedule for the larger counties to get GAP rolling. And they even have pushed that out so that there can still be further discussions with the bond companies, the banks, and everything to figure out exactly what it is that they're wanting. So I think for the time being, we might see a little bit more movement with this new session. It's a short session, but a lot of times they'll deal with these types of topics a little bit better because they've got so many other in the long session with the budget and everything. So I think at that point, how that they really visualize the GAP getting implemented will come to fruition. So we'll get to that. Surety bond. So anyone that receives, processes, deposits, or disperse money should have a surety bond. So everyone in the treasurer's, auditor's office, clerks, health, transfer station, county home, etc., needs a bond. And then there was another question, comment. Please address surety bonds. Everyone in our office handles money at some point. Should everyone be bonded individually? What about part-time help in the treasurer's office at tax time? Can we wait until 1/16 to start this? Well, the effective date is 1/1/16. And I'm going to read out the code again. And it says, except as provided in subsection B, the following city, town, county, or township officers and employees shall file and maintain in place an individual surety bond during each year. And it goes through the list that we're all familiar with, which includes the auditors and the treasurers and the clerks and everybody. And then the new subsection states, individuals who are employees or contractors of a city, town, county, township, and whose official duties include receiving, processing, depositing, dispersing, or otherwise having access to funds that belong to the federal government, the state, or the political subdivision, or another governmental entity, the fiscal body of the city, town, county, or township may, by ordinance, authorize the purchase of a blanket bond or crime insurance policy that is endorsed to include faithful performance to cover the faithful performance of, and includes aggregate coverage sufficient to provide coverage amounts specified for all employees, commission members, and persons acting on behalf of the local government unit, including those officers, employees, and contractors described in subsection A, who are required to file an individual bond under this chapter. So the answer is yes, but you can have a blanket bond. That blanket bond has to be an aggregate, though, for each one of those individuals. You're going to have to evaluate in your office whether somebody is actually performing those duties that in some way touch funds. So they're very explicit, though, that they want every individual to either have an individual bond or it can be under a blanket bond, but that has to be in an aggregate. So any questions about that? Sure. I see 5-4-1-18. And remember, that's new, and so it's not going to be on the website until, they've been pretty good about it. I would say maybe here in June, later June, they should have it updated. House Bill 1104. Does any Indiana county currently have internal control department? And that's where that if you had internal control officer and You have that department that you could go outside to an outside CPA firm if you meet all the requirements and, you know, we approve to get a CPA audit. I don't know, is there anybody here that has an actual internal control office somewhere? Okay. I even at the state level, while individual agencies have that, they don't have an overall internal control office like that, though that is a plan of theirs that they want to put into place. So, never said it would be easy to get rid of us. We have various departments, plan, building, health, who turn money into the auditor every Friday with a report of collections. Usually this amounts to more than $500. Once these departments reach $500, should they submit their money and report to the auditor, or can they wait until Friday? And that all goes back to the new bill about it being the $500 where you don't have to, daily deposit law, where you don't have to turn it in by the next business day. And what it reads is it cannot be later than the business day following the day that the funds exceed $500. If judges, oh, this is a difficult area. If judges and prosecutors' employees don't have to follow county policy because they're part of the judicial system, why are they paid with county tax dollars? Why can't they be paid by the state? I know. Well, here's the thing. It's statute. They are part of the judicial circuit, whether it's the prosecutor or the judge and their employees. There have been many court cases. The Indiana Supreme Court has ruled on this. They're supposed to work with you. I know that sometimes doesn't happen. I know that sometimes it feels unfair that they might get things that other employees are not getting. But that's kind of just the way it is. Most people, to my experience, most of the judges and most of the prosecutors do follow the county policies. And when we go into audit, if they don't actually have a policy in place, it defaults from our audit position, it just defaults to the county. And if they're doing something differently, then they can get written up about it because they don't have a policy in place, a written policy in place. And that has to happen on few occasions because the diversion, it has been way different. So I know that can be kind of hard to take. Elected official is salaried. Their wage at budget time is set for the following year. They work part-time for another department at the county. If they took a day off or it was a paid holiday, this is paid as part of salary. Can they be paid again in the part-time status? Looks like double dipping. You know, it's one thing we never ever recommended that an elected official work or be considered an employee in another part of the county. There's a lot of perception issues on that. You're an elected official 24/7. And you know that because you know you work 24/7. You're on call all the time. There are things that happen that you have to deal with. The way, from our position, that we look at this is that if you take on additional duties that are not part of your office, that's what you're doing, is you're taking on additional duties. It's not another position, because you have to also consider the salary ordinance issue. Your salary can't change for the year that it's been budgeted for. That includes anything else that, other duties that you've taken on. Now, if you make that determination in December that you'll be working over in the highway department doing whatever, and at that time you get additional monies for those additional duties, that's fine, but that can't be changed then. So you have to look at it from that perspective. You're the county auditor 24/7. You have statutory duties. If you take on additional duties that they allow compensation for, then fine, but that can't be changed salary-wise then in the year that the budget has been set. When is the DLGF fund numbers going to at least be somewhat the same as the state's? It's difficult in Gateway since they're not the same. We are well aware of it, both DLGF and us, and we're definitely working towards that goal. I think your vendors, and especially if you're new, you're kind of like, wow, can't they get their act together up at the state? The thing is that DLGF had their system. Gateway came along, and we had our fund number system. It's going to take a while from a resource standpoint to get those to blend together, but luckily your vendors have in the background in most cases been able to do some blending on that, is my understanding. But we are aware of it, and it is one of those items that we are working towards correcting. Our county bases its mileage rate on the state's mileage rate. The person who used to get this information for me is no longer working. Where can I check periodically throughout the year to make sure we are using the correct rate? Easy question, like it. Go to www.in.gov/IDOA and click on Travel Services. This has to do with jury pay fund. In our auditor's manual, the reference is to an old code number. When it came to the criminal civil case code, anything that had to do with IC 33, that area, back in 2004, they recodified it, and so our reference there is a little out of date. The new one is 33-37-10-1, just so that you have it. But the question that was asked was, for jury pay fund, why wouldn't meals qualify to be paid out of this fund? And also we are doing some minor changes to our jury room, moving the jury bench to the opposite side of the room, moving a monitor, less than $2,000 in expenses. Would this qualify to be paid out of the jury pay fund? For the easier one, when it comes to those jury room expenses, if you can show how that it maintains or improves your jury system, we will not take exception to that. The expenditures for the jury fee fund can be first to pay for the jury fees and to supplement the jury fees, and then anything that is left over unencumbered at the end of the year can go to maintaining and improving the jury system in the county. As to the meals, IC 33-37-10-1, which I gave you, is specific as to what the juror is to be paid. And this is not really changed, it hasn't changed at all actually than what's in the manual. They are paid mileage, and then they're paid an additional $15 for each day in attendance until they're impaneled, and then they get a $40. And so that's what that jury pay fund can be used, is for those two items. The fiscal body may also adopt an ordinance to pay from county funds, your general fund, some supplemental, like a meal or something like that, and so that's where it would have to come from. But that's the reason why. An auditor suggested SBOA prepare a listing of general records we will need during the audit, and that would help for a more efficient audit. We definitely agree, and we're looking into doing something like that. For some of you that have been around for a while, you kind of know what it is we're going to look at. But I think it would make it more effective and efficient. And now that we have the law changed, where we can let you know ahead of time that we will be in, that will also give you a chance to gather some of the records together. So that is definitely a good idea and something that we will work on. Okay. This one was this is a new ledge one that was a little complicated. Level 3 assessor was paid $1,000 in January and claims she is owed another $1,500 after July 1. The auditor asked if she is to disperse another $1,500 to her after July 1. Okay. Well, the statute actually goes into effect 1/1 of 2016. And the whole deal with this is what we were talking about the day before yesterday, is currently the level 2 and the level 3 assessor will receive that additional $1,000. And what they're saying is they want that to go into their salary. They don't want that to disappear on the assessors. So starting 1/1 of 16, that would be considered into their salary amount. And they don't, it's very specific actually in the statute itself that it is the repeal of the statute that allowed for the $1,000 is not to cause a reduction in the amount that the assessor was getting. Then the other part of it was to really look at it that there will be a differential between a level 2 and a level 3, and that is at least $1,500. So if somebody's a level 2, they're talking about having a schedule where salary schedule where that the level 2 salary is here, and then $1,500 more for that level 3. I realize, and Courtney and I were talking about this yesterday, that there is a little bit of language, like when they talk about a schedule, because we all know we have salary ordinances. So if you're talking about the assessor themselves, why would you need that schedule? Because you got to set their salary for the next year in the budget. I don't know if it's for them as much as maybe for the deputies. I'm not sure. We are going to talk, I think, with the Assessors Association to find out what exactly they had in mind when they were talking, because you can tell the way the language of the law is written that somebody had something very, very specific in mind for this. So we need to look into that a little bit more. There might need to be some clarifying language on that. But right now, the way that it in plain English is saying is that there is going to be that $1,500 differential for somebody that's a level 2 if they go up to the level 3 assessor. Our treasurer says they've been told by the state they cannot give out W-9s to taxpayers that request them. Is this true? These requests are coming from commercial property owners that need the information for their income taxes. Is the auditor the only office holder that can distribute W-9s? Well, I'm not sure who said that at the state level. I will say that W-9s are not generally something that government has to provide. On the other hand, I understand vendors are trying to do their due diligence and report correctly to the IRS. So, what I would do is you can maybe contact the IRS to find out specifically where you're exempted from providing that information so that you can provide that to the vendor who's asking. You can consider giving them that information. It is public. It's not exactly a secret number or anything like that. But I think due diligence on your side of just figuring out why and then helping the vendor would go a long ways to helping that relationship and to giving them some assurance. So I think you really just need to work with them. As far as who is to do that, you should really have a policy in place when it comes to any type of information like this, payroll information, of who it's supposed to go through, what approval processes you have in place, because you don't want to be giving out information that's not appropriate. So that might be in your office, it might be in Human Resources office, it might be wherever that you want it to be as a county that you make that decision, but you definitely should have a process and a person in place that's the expert that runs, is the person responsible for making sure that appropriate information is given. The monies that are paid in from the clerk's monthly report of collections for payment to DCS, can the clerk pay them directly to DCS instead of paying them in and then auditor's office doing check to DCS? We were kind of scratching our heads, so Lori and I, and actually our resource table, we were trying to figure out what monies that they give over to you that then you give up to Department of Child Services. Is any, okay. I mean, I'll check into this. I should have, when Cynthia was here, I should have just asked her that question, because there might be every now and then some money that might be given, like for, I know that they charge fees for blood tests and things like that, and so maybe by mistake money's given to the county. Oh, maybe somebody's got an answer. Yay!
I mean, that's what they're talking about.
Okay.
Is that correct, auditors? No? Don't know? Okay. Well, I can tell you from a clerk's standpoint, that's what we did.
Okay.
There was a form, and the auditor, in turn, has to send DCS a check for that amount. And honestly, in my county, we're not a real large county, but it was a minimal amount. But we could never figure out on our end of it as a clerk why we weren't sending it directly to the state. So whoever asked that question, thank you. I appreciate that, because that would be one less step that the auditor's office would have to do.
Okay.
Is anybody here that asked that?
Okay. Well, thank you. Should have called on the expert over there. That's one thing I love about people going from one office to another, because we always can get that really broad perspective. But I will contact Cynthia and I will dig into it a little bit to see what exactly the purpose and reasonings are. Of course, with the clerk's office, that's considered more of a trust fund than anything else, but there are fees that are paid directly to the state all the time from the clerk's office too. And so maybe DCS isn't aware of that and would be more than happy for you all to do that. So we'll look into that for sure. Can the commission and council be required to have so many continuing education hours? And, oh, now come on. That was by statute that it was passed for you all and for the other offices. And would it be a great idea for them as well to have education, of course, you know. And that might be something that ends up happening. I don't know, but that's something to talk with the AIC and the ledge committees about. I think that as they recognize, maybe like for internal control purposes and things like that, how much more of the, how that they are going to be held responsible in those areas, that might encourage them to participate more in continuing education. For those of you who are a little newer, I have been asked in the past what happens if you don't meet your education hours. It could be written up as a non-compliance item, especially if there are other issues in your office, because it is statutory. But I think the really big thing with this is that the Auditors Association, the Recorders Association, various associations recognized that with all of the issues occurring, and then, you know, let's face it, many of you, unless that you came up through the ranks as an auditor or a recorder or whoever, you're kind of astounded at what really the duties and functions are of the office. And the legislators recognize that you have heavy responsibilities. That's one of the reasons that for training such as this, it comes from unappropriated funds, because you need this training. It shouldn't be controlled by county councils. It needs to be controlled, obviously, if you have money or not, but not by the appropriation process. They want you to get that training, and then the associations recognize that the more that they're self-policing, that you take the forefront and say, we want this training. It was your associations who asked for this. We want this training. We want it to be required. We recognize that there's a minimum number of hours that are needed in order for us to perform our jobs well. That's really what it's all about. And as you know, we look at the county council and the commissioners. They have many, many responsibilities and duties also. So if nothing else, the county council does have a training session in June. I believe it's June 20th. It's on a Saturday. Sometimes the county auditors do go in their place, which is fine. But we would like to see the county council come with the county auditor, because it is important that they receive this training. And especially this year, we'll be talking about internal controls and their duties, so you might pass that on to them. I'd love to see participation from at least one county council member from each county. I'd rather it be all of them, but you know, I'd like to see every county represented there so that the county councilman can take back that understanding of their obligations in under this new statute. The commissioners, as I said before, we will be attending their conference, but again, yes, I understand the question. So, well, that is all that I have, and I will turn it over to Lori so that she can continue.
Good morning. I want to echo Debbie's thank you, especially to the association for the work they've put into this, and for all of you for your attention and your patience when things don't go exactly the way they're supposed to, or not as smoothly as they could. I will tell you that I did not get much sleep last night, so I apologize in advance if I fumble this a little bit, but we'll try to get through these as quickly as possible and get you on to the next part of your business. What are the rules for special purchasing involving items such as radio equipment? You need to be aware that the specific conditions of the anticipated purchase would determine which statute you should proceed. Indiana Code 5-22-10 has information on special purchasing methods, which includes situations where maybe the equipment is only coming from one vendor, or it has to integrate with the current equipment, things like that. If there are any questions on whether a purchase falls under a specific statute, you should consult your county attorney and get them involved in that. May a county attorney be a notary? Yes. This was changed in 2012. The new statute, Indiana Code 33-42-2-7, now states that for purposes of Article 2, Section 9 of the Constitution of the State of Indiana, notary public is not a lucrative office. It goes on to state a person who is a public official or a deputy or appointee acting for or serving under a public official may not make any charge for services as a notary public in connection with any official business of that office or of any other office in the governmental unit in which the person serves, unless the charges are specifically authorized by a statute other than the statute that establishes generally the fees and charges for notary publics. Property tax listed in a tax sale does not sell and then listed in the commissioner's sale. It sells in the commissioner's sale, but the lien buyer does not take title to it. Do commissioners retain the lien, or does the property revert back to the property owner? Indiana Code 6-1.1-25-4.5 states in part, a purchaser of a certificate of sale under Indiana Code 6-1.1-24-6.1, which is the public sale by the county executive of the certificates of sale, is entitled to a tax deed to the property for which the certificate was sold only if, and in subsection 3, not later than 90 days after the date of the sale of the certificate of sale under 6-1.1-24, the purchaser gives notice of the sale. And then if you go down to subsection J, if the purchaser fails to, 1, comply with subsection C3, or 2, petition for the issuance of a tax deed within the time permitted under subsection 4.6a of this chapter, the certificate of sale reverts to the county executive and may be retained by the county executive or sold under Indiana Code 6-1.1-24-6.1. Is Indiana Code 15-20-2.6 still in 2-6 still in effect? The Indiana Code 15-20-2-6 was repealed by Public Law 60-2014, Section 4, effective July 1st, 2014. And for those of you that don't have that memorized, that was the Destruction of Livestock Code. If unpaid surplus has been moved to the general fund after the 3-year waiting period, can we refund the surplus to a taxpayer if they subsequently request payments? Indiana Code 6-1.1-26-6C states in part, if the county treasurer has given notice concerning the excess may not be refunded after the expiration of the 3-year time period. If old outstanding checks have been receipted back to the ledgers, can someone subsequently request a reissuing of the check? In general, the statutes do not limit the time that a vendor may submit a claim for payment. If the vendor resubmits a valid claim, I'm doing good. Go ahead. Claim filed for that surplus? Yes. Okay. So all of those would have to go to court? Yeah. Okay. Yeah, if you could send that. Yeah. Okay. I forgot where I was. Okay. In general, the statutes do not limit the time that a vendor may submit a claim for payment. So if the vendor resubmits a valid claim, the county may issue a check for payment. We caution county officials to do their due diligence to ensure that the claim is valid and that the check has not been previously replaced. Okay. Come back to that one. Okay, do counties still have to advertise salaries from their W-2s each year? If yes, why don't other governments have to? In January of each year, all units are required to list each employee and his or her total compensation for the prior year, which is the Form 100R on Gateway. In addition, Indiana Code 36-2-219 states that at its second regular meeting each year, the executive shall make an accurate statement of the county's receipts and expenditures during the preceding calendar year. The statement must include the name of and total compensation paid to each county officer, deputy, and employee. The executive shall post this statement at the courthouse door and 2 other places in the county and shall publish it in the manner prescribed by Indiana Code 5-3-1. So that extra one is statute for counties. So whether, the others just have to do the 100R, but that's why, because it's statute. Community Corrections, a new program, wants to use 2 probation clerks as employees. There would be no additional hours, just payroll split between Probation Fund and Community Corrections Fund. Would a revised salary ordinance be required? A revised salary ordinance would be required setting the salaries for the probation/community corrections employees. The ordinance should stipulate the applicable salary from each fund and the hours required from each fund to earn full pay. Time records should be maintained to document the hours paid from each fund. There was a county bulletin and uniform compliance guideline from October 2014, which is volume 393, and on page 15, Indiana Code 5-11-9-4 provides that records be maintained showing which hours were worked each day by officers and employees of the county. This requirement can be met by preparing an endorsement on the payroll claim form showing the general work schedule and listing the specific employees who worked hours different from that general work schedule. Each elected officer or head of each department would be responsible for preparing such endorsement on the payroll claim for their office or department. If an employee is employed by more than one public agency or in more than one position within that public agency, it is also essential that an accurate record of hours worked be maintained. In these instances, we recommend that each agency and department records reflect hours worked in both positions. Has there been an update to State Board of Accounts Form 99, which is a payroll claim? That form was last updated in 1993, and that's the one that's still in effect. Is there a way for our vendors to get access to a test area on Gateway to see what effect system updates have on our ability to upload or enter information? Neither State Board of Accounts or DLGF actually owns Gateway, so we're going to tell you that for technical questions, you should contact the Indiana Business Research Center, IBRC. They do have a site at it's IBRC Tech, all one word, at iupui.edu, and request this kind of access and see where they go with that. Is there a statute requiring that someone be in the commissioner's office during business hours? Our commissioners have a secretary, but when she is out, does someone need to be there? There is no statute requiring a commissioner's office to be staffed at all times. We have $3,000 in Fund 9101, which is a Community Corrections Prime for Life. Can we move that money to another Community Corrections Fund and close Fund 9101? The Community Corrections Prime for Life is a state grant. The grant agreement would detail how the money is to be spent and what should be done with any unused balance. It's a good idea if you ever have, when you have these grant funds, if you have an unused balance, to go back to your grantor agency and ask them what is allowed with this money that is left over in this fund that has not been used. Can you move Community Corrections Fund 8120 to Project Income Fund 2540? Again, that's referencing a grant fund, and you still would need to contact the grantor agency, whether it's state or federal, to determine what can be used with that unused balance. The Project Income Fund, the 2540, is a statutory fund, and there are statute guidelines on what can be put in that fund. If you look at Indiana Code 11-12-2-12A, money in the fund at the end of a fiscal year does not revert to any other fund. This fund consists of fees deposited under subsection B. Money in the fund may be used only for the provision of community correction programs, including services allowed under Indiana Code 11-12-2-5, section B3. So the program income fund restricts what money can go in there, so you can't just move money into that fund. What can be done with the balance in our cumulative jail fund if the fund has been dormant for years? If the cumulative jail fund was created under Indiana Code 36-9-15-2, then Indiana Code 6-1.1-41-14 and Indiana Code 6-1.1-41-15 would govern expenditures or other disposition of the remaining fund balance. The first one, Indiana Code 6-1.1-41-14, states the tax collected for a fund must be held in that fund for which the tax was levied. This fund may not be expended for any purpose other than the purposes specifically specified by statute authorizing the fund, except to the extent that Indiana Code 8-16-3-3C, Indiana Code 14-27-6-48C, or Indiana Code 36-9-14.5-8C and Indiana Code 36-9-15.5-8C, or other statute specifically provides a different procedure. Expenditures may be made from the fund only after an appropriation has been made in the manner provided by law for making other appropriations. And the second one, Indiana Code 6-1.1-41-15 states, if the political subdivision establishing a fund decides that the purposes for which the fund was established have been accomplished or no longer exist, or rescinds the tax levy for that fund, the governing body establishing the fund for the political subdivision may transfer the balance in the fund to the general fund of the political subdivision. The money in the fund does not otherwise revert to the general fund of the political subdivision at the end of the political subdivision's fiscal year. What may I do with the $1,000 that lies dormant in the Commissioner's tax sale fund? I'm making a few assumptions here. If you're referring to the fund 1203, tax sale fees, that fund was established to collect the fees due your vendor for holding the tax sale. So there shouldn't be a balance in there because the money that went in it should have then been remitted to the vendor. We realize that counties have used that fund for other purposes than just the vendor fees. So we really don't have enough information on where that. Then you wouldn't need to use that fund. Right, back to the fund that paid the original cost, you can reimburse that back. So you use it as, with the county being basically the vendor, is what you're saying.
I just wanted to throw that out.
Right. Does it zero out after the tax sale, or does their money stay in for the next?
There are some, my question was, there are a few counties that do their own tax sale, and at that point, you have to estimate the tax fee, because you don't know and the tax fee gets put on each property, but you don't know which ones are going to sell and which ones you're not going to sell, and if you're going to collect that money or not. So sometimes the fund has extra money in it, and sometimes it doesn't. And so you take the balance in the next year, and you roll that into your estimate of the fee for the following year. That's how we kind of do things in Allen County.
So you would know what that $1,000 was in your fund if it was your fund? Yes. Okay.
And one thing that I will say with this particular fund in the chart of account, when it was developed, it was because that a particular vendor wanted their money segregated out, and that was the concession of a fund for that purpose. Generally, those kinds of costs, and I think Tara's aware that other counties, they'll go ahead and pay out of their general fund for those costs, and then it gets reimbursed back to the general fund. And so that's generally what would occur, and that's, I want to give you a little history, though, of why that fund was created, because what we've found has been occurring and is a little concerning is that all of the monies have been going back into this fund after the sale, and there has been huge balances in some places, and because you know that it first goes to the cost of that certificate sale, then the monies, and the statute doesn't give an order to this, but for the actual original tax sale, there's the costs and then the taxes. And that money should, if there's money left over from the certificate sale, then it should be going against the tax sale costs and then distributed to the units. Or it could go to the units first and then the cost of the county, because like I said, that statute does not give a priority of how those monies are applied. So we've run across at least 2 counties where they had thousands.
Oh, millions.
Millions, okay. I didn't want to say millions because it kind of scares me. And really those monies should be going over to the taxing units for their share of those costs. So be very, very judicious and careful when using this fund. Tara has a system in place on how that she's doing this, but yeah, she's only the fee. She has really segregated things out and is tracking this money. So be very, very careful, because otherwise you'll run into a situation where there's all sorts of money in there, and you don't really. It probably belongs to some of the units of government because they are entitled to their share of any sale of property, with very, very rare exceptions. But under the certificate of sale, hey, there's enough money, they should be getting their share of it. So I just want to give that caution to that. So, okay.
I have a fund into which was placed the proceeds from the sale of land to the Jail Building Corporation. The fund has lain dormant for years. What may I do with this fund? Since these proceeds were placed into a separate fund, the fund should have been created by ordinance. Expenditures from the fund should be in accordance with the uses specified in the ordinance. If there is no such ordinance, the proceeds should have been quieted back into the fund from which the land was purchased, or if that fund no longer exists, the general fund. How long do we need to keep W-2s and 1099s? There is, and I will give you the website on the in.gov/ICPR, which is your public records, Indiana Commission on Public Records, although they're changing their name. There are retention schedules. If you look on that website and go to the general retention schedule, it does state that you need to retain those documents as long as it is expected by the federal government, whatever their regulations are, because those are federal forms, but no less than 6 years. So anytime you have a question on how long you need to hold things, that's a good place to check on that as well. Can an auditor call an executive session? Okay. We talked about this quite a bit yesterday. If you go to the code, Indiana Code 5-14-1.5, and you go to 6.1, which talks about calling the executive session, that statute really doesn't say who can call it. There is a code, I can find it now in my mess. Indiana Code 36-2-2-8 on special meetings, and it does state if the public interest requires a special meeting, and I'm not sure whether the executive falls under that, but a special meeting of the executive, such a meeting may be called by a member of the executive or by the county auditor, the county clerk, if the office of the county auditor is vacant, or the county recorder if the offices of county auditor and county clerk are both vacant, which in case they've got a real problem. So we would not take audit exception if the auditor is calling an executive meeting, but if you're in a disagreement on who can call that, you need to check with your county attorney and get that cleared up. And we can't give you legal advice on what's legally there, but we would not take audit exception to that. Questions regarding the contracting policy. Are the nepotism and contracting policy the same? No, they're two different statutes. Nepotism is dealing with employee and supervisor and the relationship between the two, and the contracting policy is dealing with your contracts for goods and services. So there are two separate statutes. There is also I didn't write it down, but I think it was the July 2012 bulletin did go over those two separate statutes and put a lot of detail in our audit position on each one of those. I'm not going to read all of that to you, but that is a good place to look. They also, we would suggest that if you have a question about a sample of what a contracting policy should look like or a nepotism policy, to ask other auditors who might have passed one, or with your association if they have a template for it. But they are two separate things. A county auditor presented an ordinance for the transfer of the cash balances of several dormant funds to the rainy day fund. I'm not sure what the question is on that, but you can transfer to the rainy day fund. Those transfers may only be made from other tax revenue funds. If you go to Indiana Code 36-1-8-5, it does state funds raised by general or special tax levy, disposition of unused balance, transfers to the local rainy day fund under Section 5A. This section applies to all funds raised by a general or special tax levy on all the taxable property of a political subdivision. Under B, whenever the purpose of the tax levy have been fulfilled and an unused and unencumbered balance remains in the fund, then the fiscal body of the political subdivision shall order the balance of that fund to be transferred as follows, unless a statute provides that it be transferred otherwise. And also the October 2005 County Bulletin does have some information on the dormant funds. A lot of the questions, some of them kind of relate to what to do with your dormant funds. Many counties have found, this is from the bulletin, many counties have found funds that have been inactive or dormant for a number of years. A sufficient fund balance should be retained to pay any outstanding obligations, such as bonds and interest coupons not surrendered for payment. However, to the extent of any balance not needed to cover outstanding obligations, every effort should be made by county auditors to eliminate such funds from their records. And the following statutory authorities will be found governing the closeout of the above listed funds. Indiana Code 5-1-13-2 provides that when bonds have been issued for any lawful purpose and the purpose for which the debt was incurred has been accomplished or abandoned, the surplus or balance in such bond fund shall be transferred to the Bond and Interest Redemption Fund by the disbursing officer upon order of the legislative body. The funds so transferred are to be used for the payment and interest-bearing indebtedness. Indiana Code 36-1-8-5 is a general law which provides that unused and unencumbered balances in a county funds which have been raised by levy on all of the taxable property of the county be transferred to the county general fund or rainy day fund upon authority given by the county council. This section also provides that unused and unencumbered balances in funds for the redemption of poor relief bonds or like obligations for poor relief purposes by levy on all of the taxable property of a civil township be transferred to the poor relief fund of such township. We do encourage you to examine your dormant funds, do your due diligence to try to figure out where that money came from, whether it was a grant, whether it was bond, whether there's an ordinance, and you may have to dig to find some of those ordinances establishing those funds and determine where that money needs to go so that you can start using it again. It's volume 353, page 5, October 2005. Is there a statute that allows the county auditor to charge a transfer fee for each lot on plats? This would depend on the ordinance. Indiana Code 36-2-9-18D states, the legislative body of a county may adopt an ordinance authorizing the auditor to collect a fee in amount that does not exceed $5 for each deed or legal description of each parcel contained in the deed for which the auditor makes a real property endorsement. This fee is in addition to any other fee provided by law. The auditor shall place the revenue received under this subsection in a dedicated fund for use in maintaining plat books. The county has always received certified checks received from bidders rather than posting and depositing the checks. Is this allowable? Okay, this is coming from Indiana Code 36-1-12-4.5. A bond or certified check shall be filed with each bid by a bidder in the amount specified by the board if the cost of the public work is estimated to be more than $200,000. The amount may not be more than 10% of the contract price. The bond or certified check shall be made payable to the political subdivision. All checks of unsuccessful bidders shall be returned to them by the board upon selection of successful bidders. Checks of successful bidders shall be held until the delivery of a performance bond. Okay. Is it allowable to add insurance reimbursements back to the appropriation? Indiana Code 6-1.1-18-7 states, notwithstanding the other provisions of this chapter, the fiscal officer of a political subdivision may appropriate funds received from an insurance company if 1, the funds are received as a result of damage to property of the political subdivision, and 2, the funds are appropriated for the purpose of repairing or replacing the damaged property. However, this section applies only if the funds are in fact expended to repair or replace the property within the 12-month period after they are received. Are the large hardbound books required to be maintained for the minutes of the commissioners and council? No, the minute form is not a prescribed form, so you do not have to keep it in those books. That's your choice. Who is the secretary of the Drainage Board? Indiana Code 36-9-27-7A states, the board shall organize at a meeting each January by electing one of its members as the chairman, one of its members as vice chairman. At the same time, the board shall elect a secretary who need not be a member of the board. Is a resolution required for ditch reconstruction? That's got a lot of, I'm not going to read all of that to you because we could be here the rest of the day, but Indiana Code 36-9-27-52.5 lists the procedures in detail required for authorizing drain reconstruction. Who has the authority to initiate a drain loan? And I have that here. I am, again, making an assumption. That you're talking about a construction loan for a reconstruction project. And if you go to Indiana Code 36-9-27-97.5, whenever the board determines by resolution spread upon its minutes that the cost of constructing or reconstructing a particular drain in an amount that the owners of the land to be assessed may conveniently pay in installments over a 5-year period, it may ask the county fiscal body to obtain a loan from a bank, trust company, savings association, or savings bank authorized to engage in business in the county. And if you go to 36-9-27-3, it states that the rights and powers of a political subdivision under this chapter as an owner shall be exercised on behalf of the political subdivision by the Works Board for a municipality, the executive for a county or a township, and the fiscal body for any other political subdivision. So, gives you who has ultimate control, I guess. Do we claim $33 per day for the conference, or do we just get reimbursed for food and mileage? We kind of talked about this late yesterday, and I assume you're talking about for a state called meeting. For us, you pay mileage at the county rate, you can pay subsistence, or you can pay actual receipts, and that's whatever your county policy is on that, so you follow that. You wouldn't do both as far as the actual receipts and the 33 and the per diem. I assume the 33 is a per diem. If a person produces an old check that has already been receipted back to the record, should we issue them a new check? I think we answered that in 7. Again, that the statutes do not limit the time that a vendor may submit a claim. So if they do resubmit a valid claim, you can issue a check for payment. Just make sure you do your due diligence and make sure that that claim has not been paid in the past, or a replacement check hasn't already been issued. Who has the authority to require direct deposit for payroll? Can the auditor make that call? Again, we can give an audit position, not a legal. I can't give you legal advice on that. If the Indiana Code 26, let's see, I copied that one out too, on somewhere I did. 26-2-8 talks about financial transactions, or all transactions conducted electronically. It does give you the right to do that. I think we would certainly not take exception to the auditor making that call, because you have control over the payments, the checks, how that's being done. If you look at one more. If you look at Indiana Code 36-2-8-2 on salary and wage periods and manner of payment, it says the county auditor and county treasurer may pay salaries and wages to county officers' employees monthly, twice each month, and every 2 weeks or weekly. Then it goes on to say, the manner of payment of salaries and wages under this section must be authorized by the legislative body of a county having a consolidated city or by the executive of any other county. And this is back from 1980. I don't think they were even thinking about electronic payments, so they were it's probably referring to whether you go biweekly, monthly. So we would not take audit exception to the auditor making that call, but again, to go back to it, if there's a dispute in the county, it's a good idea to talk to your county attorney about what the legal basis is. Is the handbook committee the same as the personnel committee? Are there specific offices on this committee? These committees are not organized by statute. They're determined locally. So they're really something that's it's your decision as a county how you want to do these committees and who you want to be on these committees. Can we pay the deputy who completes transfers in the tax system out of the transfer fee fund? Also, can the plat book technician be paid with these monies? Again, we're assuming you're talking about the fund we talked about earlier, created 36-2-9-18, titled the Plat Book Fund. It's Fund 1181 in our chart of accounts. And if you go to that statute, the legislative body of a county may adopt an ordinance authorizing the auditor to collect a fee in the amount that does not exceed $5 for each deed or legal description of each parcel contained in the deed for which the auditor makes a real property endorsement. The fee is in addition to any other fee provided, and it should be placed, the revenue placed in the dedicated fund for the use of maintaining the plat books. Any expenses from that fund, we are going to be auditing back to, is it maintaining the plat books? So I do not believe we would take audit exception because based on the limited information I have, they look like that's what they're doing, is maintaining that plat information. But you should have documentation to support that. Can the clerk 4D monies be used to pay bank fees and service charges for individual bank accounts which 4D monies are in? The clerk 4D fund that they keep in a separate bank, that's a trust fund, and the money they collect and place in that is money that they've collected for child support to be ultimately sent to the children through the support order is established. That cannot be used to pay that. Bank fees are operating expenses of the clerk's office. They should be a claims process used and come out of their operating budget to pay those bank fees. Can the county council or the county income tax council adopt an ordinance to impose a public safety tax rate without also adopting a low-it levy freeze or low-it for property tax relief rate? Again, this is changing, so keep that in mind when you're looking from July 1st forward. Currently, if the county is a Cadgett County, the county council adopts the ordinance. That's under Indiana Code 6-3.5-61.1-25. If the county is a Coet County, the county income tax council is to adopt an ordinance, and that's under Indiana Code 6-3.5-6-31. And that's all of them. Do you have any questions? Somebody did, maybe. Did we have a question, or did you? Okay. I saw a hand and then it disappeared.
Referring back to charging for the plats, on the statute that you read, it keeps referencing deed transfer. Now, I know a plat transfers lots, but a plat is not a deed, so do you think that's pertinent to both?
Could you repeat what you're saying?
The question was there any statute that covered where we could charge per transfer for, say, if there's 100 lots in a subdivision plat? Now you can, per the statute, we can charge $5 per legal description. That statute does not reference plats at all. It just keeps referencing deeds. So I guess our dilemma is, are we just to assume the language includes plats and have an ordinance developed that would include those fees as well, where we could establish those fees.
I can see where your mind is. I think that we have answered that before, and it's tickling in the back of my head, and then I thought that it was okay to do that. I can confirm that, to be sure. Tara's memory, I know, is better than mine on these things. She's probably asked the question before. But I can confirm that, but I do believe that is the case. So
I did send out an email to all the other counties, and so far I can't find any that are charging for individual lots. Oh, okay. Let me, and actually I'm going to talk with Tara a little bit about this, and we'll actually go ahead and send out an email to everyone once that we get all of our authoritative reasoning in place for that, because I think that's what you're looking for, is the authoritative reasoning. So let us get that pulled together. Go ahead. Mm-hmm. She's answering me, and so yeah, we'll get that out to everybody. But what Tara's basically saying is that the legal description for each for the deed has that in it, and so that's what the basis is to be able to charge it for each one. Okay, so thank you, Tara. I love your memory.
Hopefully this is simple for vendors. I know the IRS has a code on W-9 forms that we have to send out to our vendors. Are there any restrictions in terms of, because it's a $600 limit per IRS, that dictates when we send that or request a W-9 from the vendor? Are there any codes or rules or just generalities? Do we get that from every vendor that the county does service with, or what's the procedure on that?
It's an IRS rule, so it would be, they would determine, I think they expanded it, but I'm not talking for the IRS. You would need to talk directly to them. You know, is it just everyone over $600? I would call them and ask them.
Does anybody else know? So does everybody else send out or request a W-9 from every one of your vendors that does service over $600 with the county? Yes? Okay. Sounds good to me.
I have a question about the auditors in Bellegi Fund. I'm not sure what I need to do with that. Is there a time limit on that?
Oh. When you say time limit, what are you referring to?
Well, I was told that I had till next January 2016 to deplete that fund. Is that true?
No. The statute is that you can't accumulate in that fund any more in receipts than $100,000 per year. You can accumulate from one year to the next, but you can't accumulate more than receipts net of the contract if you have any contractual for research for these ineligible homesteads. So no, you don't have there's not a set deadline to get that depleted all the way down.
Thank you.
Tammy, I think this, or Debbie, I think this goes to you, I'm sorry. I had a judge that held a staff meeting, and he put in a claim against his jury fund for that meeting. They didn't go off-site, they held it in the county courthouse building. So how do I respond to that?
You know, it's from our audit perspective, we will never tell you not to do what a judge orders, ever. However, you can document that, and if it becomes an exception, it will become an exception against the judge. So.
Thank you.
Mm-hmm. Now, you might want to educate your judge. Okay. And you being a clerk, former clerk, you know how that goes. So, no, some of them are very much wanting to be educated. Others, maybe not so much. Any other questions? Oh.
Okay, now this is another question on the homestead ineligible fund, the ineligible homestead fund. If we have to issue refunds after it's been determined that the homestead that was yanked really should not have been yanked, we're taking those refunds out of the homestead fund, the ineligible homestead fund. Is the amount that we have to return back to the general fund over the $100,000 net of the contract costs also net of the refunded amounts?
Yes, because that's talking about you've receipted in, but you've also taken out in the same time period. I do kind of get what you mean when you're talking about over years, because now you've kind of messed that up a little bit. How often has that happened to people where it goes from one year to the next?
It's going to happen often because you get the money and they don't realize it until when they get their escrow statement, or even then they'll pay it for a couple of years and then they realize it. And so I think it's going to have to be netted against the revenue in the ineligible fund. And if you run out, then the general fund, as long as you can show that you made a deposit of that revenue, yeah, it's tricky.
Yeah, and that is one of the reasons for the ineligible homestead. You have to keep great records, and that's the other reason that when it comes to that netting process, you have to keep track throughout, but if you have to do catch up at the end of the year, we definitely don't take exception to that. So I'm just trying to think if there's a better way to do it, but we'll kind of think about it a little bit to think about if there's a better way, but I definitely think Tara's right in that people all of a sudden are going to go, hey, wait a minute, I could have been getting this all along. There's no real statutory restriction on going back in time to giving them that money. So, now the good news, there's no interest owed on that money either. Okay. So let's not go down the 17T path, though you can use that as a kind of a claim, because right now we don't have a better claim, for documentation, but it's also kind of a messy form to use for it too because of the interest. So, but anyway, we'll think about it and see if there's anything better, but I think you're just going to have to keep really good records on it.
Can I ask a follow-up question on the assessor pay, the new law with the assessor pay?
No.
Okay.
I'm just teasing. Go ahead.
Well, I'm just a little confused about how this additional pay has to be paid as part of the annual compensation. How we do it in our county is that the so-called bonus pay is paid out of the reassessment fund, but of course the assessor's regular pay is out of the general fund. So would we have to roll that $1,000 or $15,000 into the regular pay, or can we still segregate that amount?
Well, you can, I mean, when it comes to your payroll, you can always draw it from any correct funding source. But that might be another, I hate to get too theoretical on some of these laws when they're getting passed, because I don't think they were thinking about the assessor's fund being used for that bonus amount. As a matter of fact, I can almost guarantee it that that wasn't part of their thought process. And by them saying that now it's supposed to be viewed as compensation, does that change that? That's something we'll have to, I think that's another good question, and one that we can talk with whoever was responsible for that law. So that is one of the more perplexing laws that we've had this year. So it seems simple. I know whoever passed it thought it was very clear and very straightforward, and just do it. And the more questions that are getting asked, because there's also the phrase in there too that the $1,000 can be taken into consideration of the total amount. I don't know exactly what that means either. So we'll be looking into that. But thank you. We'll ask them about that too.
Any other questions? Don't forget your registration. Enjoy your meeting. Have a wonderful Memorial Day weekend.